Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. Here you'll learn about divorce, family law, tips on how to save your marriage if it's in the middle of a crisis, and from time to time, even tips on how to take your marriage to the next level. If you want to learn more about us, you can always check us out online at AtlantaDivorceTeam.com. All right. Todd, you ready?
Oh, I'm always ready. I don't know if I'm going to hear or learn or whatever. I'm here, so
here.
I'm ready to go.
All right, good.
So what are we talking about today?
The top divorce and family law mistakes that we see litigants make. So not just people represented by lawyers, but pro se litigants too.
So let me translate that into actual English. The top mistakes people make in divorce cases.
Yes.
Okay. All right.
What did I say?
I think you were just doing a word jumble there.
I was trying to wake you up.
We try to keep people on their toes by top mistake, Attorney Jeff. What? All right,
Okay.
So top mistake. So the whole point is, whether people are trying to handle things on their own or even if sometimes they get an attorney, there are things that people do, mistakes that people make that we constantly recognize. We constantly advise people not to make them or how to avoid making them. And even when people are represented by an attorney, sometimes they just act in certain ways that actively harm their case. So these are the kinds of things that we're talking about. Mistakes that people make that can negatively impact and sometimes significantly impact, your divorce.
Massively impact.
Absolutely.
So we're going to talk about what we see, and these are not legal mistakes. So we're not talking about mistakes that a lawyer could make in court or something like that, because, well, that's really hard to do because every case is so fact dependent that, sometimes attorneys make judgment calls based on what they think the judge is going to.
Strategic decisions.
Right.
Right.
So we're not going to talk about that because, for most people out there, that's outside their control. Apart from choosing their lawyer, the rest of that's outside their control. So we're going to talk about what people can control, things they can do during the case, or things they should avoid during the case, so that they have a better outcome, whether it's by settlement or in front of a judge.
All right. So what's the first one?
So third-party advice. One of the most challenging things as a lawyer is hearing, well, I heard that so-and-so who got a divorce in the cul-de-sac that's right next to ours, well, in her case, she got this much in alimony and this much of the marital estate, and I think I should get the same thing.
Yeah, my uncle's neighbor's pet turtle got a divorce and got $15,000 a day, of alimony. We deal with that all the time. Jokes aside, people will call and clients will come in, and part of our job. Let me take a step back and say, part of our job. A big part of our job is to set expectations, to give our opinions and to say, okay, this is what I think based on all of the facts and circumstances in your case. This is what I think you can expect on whatever the issue is that we're talking about.
In front of this particular judge,
that's
too.
Right. That's right. So that's our job, to set the expectations. The problem is sometimes people will already have these preconceived notions, these expectations that have been set by talking with other people, not lawyers, not people who practice family law. And a lot of times it's just wrong.
Yeah.
And so it's not that, like, I'm one of those people, I'm one of those attorneys who will be like, look, if you have somebody that you can rely upon that you want to talk to, do it. This is a very emotional time for you. And if you have someone you trust, then absolutely don't shut the door to communication with that person. But sometimes I'll hear the advice that's being given, and I'm like, you need to shut that door.
Oh, yes. And, I had a call not too long ago where someone called in and we didn't handle the original divorce, but they were calling about an alimony modification. And I said, well, I talked to two of my neighbors and they said they got lifetime alimony. Well, I only got 12 years. I think something went wrong in my case. And so I asked them, I knew this person was calling from Florida, but their divorce was here in Georgia. So I asked them, now, did they happen to get divorced in Florida? Well, yes, they did, as a matter of fact. Well, in Florida, there is lifetime alimony. It's in a statute, and if it was several years ago, after so many years of marriage, there's a presumption of lifetime alimony awards. Not here in Georgia, and so I had to explain that to her. So that's when you start listening to other people's cases. They may have been dealing with a different time where the law, the law's constantly changing. So maybe they got a divorce 5 years ago and the law has changed since then. Or maybe they got a divorce in front of a different judge that thinks a different way, or another state.
Or it could just be that there was an agreement between the parties.
Right.
And one party gave away the proverbial farm because of whatever reason. I wanted to be generous. Out of issues of feeling guilty. Maybe they had an affair and they felt really bad. And so they gave away a lot more than maybe they needed to. Mm-hmm. And then someone will come in and go, well, that person got $10,000 a month and their income is X. And that's similar to my situation. It's like, yeah, but hold on one second. Did they have a trial? Did they actually? Because your husband or wife is saying absolutely not to those types of numbers.
Right.
And I don't think you're going to get that from a judge. They got it by means of an agreement.
Yeah, so you want to listen to your lawyer's advice over the advice of third parties, especially about what may have happened in their divorce cases. There may be some exceptions about that, and we can talk about that some other time.
So that goes into the next one, not listening to your lawyer.
Right. Okay. And so putting aside the third party stuff, a lot of times, and it's completely understandable. I'm not saying that the person who's doing this, I'm not saying they're a bad person or they're a stupid person. I'm not saying that at all. When divorce is, there's not too many type of situations dealing with court that are going to stir up more emotion than a divorce. And a lot of judges have classically said, I've seen criminal cases where the criminals come in, you got bad people acting on their best behavior. In divorce, you have good people acting at their worst. And it's the emotions are running high. And so what happens is they hear advice from their lawyer and they don't want to hear it because it's not what they, perhaps they feel like the other side needs to pay. Maybe there was adultery involved and they say, well, that doesn't seem fair. How is it that he's not being punished for that? Or why is it I have to pay all this alimony? She should go out and work. So you have these things. And when you don't listen to your lawyer and say, no, I understand that, but here's how the judge thinks about this issue. And here's how the judge is going to apply your facts to the law, and that's why you need to settle. And so some people will just say, well, I want to roll the dice. I want to go before the judge. My case is different. And you're sitting here, and from our standpoint, no, it's not. I tried 3 or 4 cases like this in front of the judge, very similar facts to yours. Not exactly the same, but very similar. And this is what the judge did. And then you go to court and, unfortunately you get the outcome that you expect. And it's not that some people are like, well, if that's what you're thinking, that's what we're going to get. I'm like, no, we're going to fight like heck for you in the courtroom, but I'm just telling you.
Look, the way I put it is, if you're going to spend the time and effort and money hiring an attorney to represent you and give you the advice that you need to make good decisions, then you need to trust that person. If you don't trust that person and the advice that that attorney is giving you, then it's time for you to find another attorney, all right? Because what happens is, if you ignore that advice, again, you hired the person because they understand the law, they understand the application of the facts in your case to the law. Yeah. They understand who the judge is and which way a judge potentially leans on any given issue. Now, saying all of this, that doesn't mean that you don't question strategy. That doesn't mean that you don't work hand in hand with your attorney to talk about the pros, the cons, the strengths, the weaknesses, and come up with a strategy. There are plenty of times where we've looked at clients and we've said, you don't really have much of a shot, or the percentage chance of succeeding is very low. And our client goes, I need to fight the fight. All right,
Yeah.
for whatever reason,
Right.
I need to put this in front of a judge. Fine, done. We will fight tooth and nail for you and present the best case possible. But we're talking about simply shutting down and not listening when your attorney is giving you advice, and it could be advice on settlement, but it could also just be advice on behavior.
Yeah, and so the other thing I think a mistake I've seen some people make is they'll not listen to the lawyer. They'll call another lawyer, not give this lawyer all the facts. And it's not that sometimes the clients lie, but there are some times when, not our clients, but sometimes people lie. But then there's other times that they just say what they think is important. And the lawyer says, well, here's my legal advice based on what you told me. And so they switch lawyers. They spend a ton of money switching lawyers. And then they get in front of this, this new attorney, and the attorney gets the rest of the facts, or they get the whole file from
They're
their previous
back where
lawyer,
they started.
and they go, oh my gosh, you didn't tell me about this. Oh no, this is not good. So it's like you said, and we're not saying it's that you shouldn't question your lawyer. We're not saying that, because you should understand why a strategy is being taken. What we're saying is, once that's been fully vetted, you really need to listen to your attorney. Hey, up next, we're going to dig into more common mistakes we see. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orson. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. If you want to learn more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we're talking about the common mistakes that we see people make in divorce cases, because unfortunately, sometimes, the litigants, the people that are involved in the court case, they can become their own worst enemy. And so what we're trying to do is share things with you that we've seen, that people have made mistakes. And if you can avoid these things, you're going to be a lot better off. All right. Number 3.
What I'm going to call head in the sand. Okay. And that's failing to act and procrastinating or putting things off, which ultimately results in you just not doing basic things that need to get done, and your failure to do those things can absolutely negatively impact you in your case.
And so we've seen this a lot with cases where you may have, I've seen it from both extremes, like someone who doesn't want the divorce. So they think that, well, if I just bury my head in the sand, it's just going to go away. If I don't file the answer, they can't get a divorce. Well, if you don't file an answer, they can get a final hearing, and not give you notice of that filing hearing. This is in Georgia. And they can get a judgment against you. And we've seen just things where the spouse got 100% of the marital assets, and this outrageous amount of alimony. When I say outrageous, meaning it was more than the person made. So you can't ignore the problem. You can't, if you're struggling and which we've seen before, we totally get it. This is one of the most stressful things anybody can go through, is a divorce. But if you're at that stage where you're having trouble coming to grips with the fact that your husband or wife has filed for divorce, you've got to get into to see a counselor to work through this, and you've got to put your trust in your lawyer that they're going to file what you need to have filed. Okay, so don't put that off. Don't ignore discovery. So if someone sends out discovery requests and say, well, if I don't answer, then, the case is going to go away. No, because they can go to the judge and then get an order ordering you to turn it over, and then you're going to have to pay the other side's legal fees and everything. So we've seen that happen. And on the other end of the spectrum, we've seen people that have made a mistake in their marriage. Maybe they've cheated. They've committed adultery. And so they say, well, I'm going to give up. She can have everything, he can have everything. I'll pay whatever they want in child support and alimony. No, that's not a good thing either. Yes, you've made a mistake, and you may have to pay for it, depending on the circumstances and the judge and all that sort of thing. But don't do something foolish like giving away the farm, because all that does is hurt you in the future when it comes to your children.
Yeah, and again, feeling guilt about, let's say, an affair. And I'm not sitting here defending adultery.
Right.
But, suddenly saying, I got caught in this affair, I'm going to give up on everything. Understand that adultery, as long as it was kept away from a child, it's not going to have any bearing on custody. It's not going to have any bearing
for
on
most judges.
For most judges, correct. It's not going to have any bearing on child support. Alimony is not punitive, so it shouldn't have any bearing on alimony, and it may have an impact on division of property. So if you're walking away from the table and not negotiating on anything, well, clearly you are causing yourself harm, because the other party may get a lot of things that you wouldn't have had to give up had you just stayed involved.
Right, and it doesn't mean you have to get ugly about it, or I don't say fight, but still you negotiate for something that's reasonable.
That's right. All right, so let's go to number 4.
All right. Agreeing to terms of a settlement agreement based on external oral promises. So meaning that, hey, if you sign this document, I'll let you, this document says you have to pay $1,000 in child support, but I'll only ask for $800 a month or $500 a month.
Or where I see it a lot. Let's just do a weekend kind of parenting schedule. But don't worry. I'll let you have a lot of time with the kids.
Yeah.
So it'll be a Friday to Sunday standard, maybe a week during the summer. But don't worry. Whenever you want to see them and spend time with them, you can.
Mm-hmm.
And people reach an agreement. They sign off on it. They don't talk to an attorney. And lo and behold, a week in, month in, year in, all of a sudden, the other party, there's a fight, an argument, whatever, and the other party's like, no. You have every other weekend and a week during the summer, and that's what you're getting, and that's it. And at that point, coming back and trying to modify, to undo what was done, if there hasn't actually been a change of circumstance, may be difficult or impossible.
Yeah, and you can't say, oh, well, they promised me this or they promised me that. Because most of the time these agreements have clauses saying there are no external oral promises, and it's a court order. The court's not going to undo a previous court order. So don't enter a settlement agreement based on what someone else has promised you. If they really intend on honoring that verbal or oral promise, then it should be in the written form, because if it's not in writing and doesn't become part of the court order, the final court order granting the divorce or whatever, whether it's a child custody action or legitimation, whatever it may be, it's not enforceable.
Yeah, I sometimes jokingly say to clients that part of my job, part of my role is I get paid to be paranoid.
That's true.
I get paid to think about sometimes the worst case scenario in the future.
Mm-hmm.
And while you may not be just at war with your soon-to-be former spouse, okay, understand that after a divorce, the relationship is changed.
Mm-hmm.
And the person that you are trusting will do the right thing, may do the right thing, but they may not.
Yeah.
Or something may happen that they feel justifies doing something different than what they orally promised.
They get in an argument, like you said earlier, or what we've seen is one or both of the parties has a new significant other.
Right.
And then all of a sudden that significant other says, well, why are you doing something that's outside your agreement? And the person goes, oh, well, I guess maybe we'll follow the agreement.
And it's interfering because I have visitation with my kids, and I want to do this on this weekend, or I want to go away on this vacation during the summer, and you're giving all this extra time. No, don't. So things change. So whatever, you hit the nail on the head. If it's going to be the agreement, if that's what everybody agrees should be the terms of the agreement, make those the terms of the agreement.
Right, written agreement.
The written agreement.
Yes.
Okay. All right, next, number 5, signing a settlement agreement before you talk to a lawyer. Okay.
Big no.
Yeah. I typically will tell people, first of all, just like any business meeting, I don't care what you do for a living. If you're going into an important meeting, if you're trying to make the sale, if you're trying to close some kind of a deal, if you're whatever it is, you don't go in cold. There is some level of preparation that you do.
Mm-hmm.
Why on earth would you go into a conversation that could potentially morph into a negotiation regarding settlement terms in a divorce without doing some preparation? So I typically tell people, before you even get to the point where there's an agreement to sign,
Mm-hmm.
I believe, and I'm not saying this just to try and drum up business, You talk to an attorney, educate yourself so that when you sit down, you are educated, and when the other party throws something unreasonable at you, you can say, "Oh, wait, hold on one second. My understanding is that this is how that issue is handled. So I'm not sure that's really reasonable," and you can have a good, honest conversation and defend yourself.
Yeah. And to go to your point, you don't have to actually fully hire a lawyer.
That's right.
You can just come in for a consultation for, $300. That's what the charge we normally have, and talk with them about what is common in the court system, what might be a good idea for their particular circumstances, what they should be thinking about, what is reasonable, what's unreasonable, at least from the court's perspective. And then when you have that conversation, like you said, the cool thing, we need to have a show just on negotiation techniques, because one of the things is it's not you rejecting it, it's a third party rejecting. We say, well, my understanding is the courts, they don't like that, so I'm not sure that would fly. Here's the other reason. Well, I mean, you may enter an agreement that you shouldn't, and that can, the question of it being enforceable, that's a whole nother issue. But sometimes you can enter an agreement, especially if the case is active litigation, that can be enforced by the court. So maybe you have a situation where your spouse is pressuring you. Let's settle. And we're all about settlement. But what you do is you listen to them. You can say, okay, my understanding of your offer is X, Y, and Z. Did I get that right? Oh, yes, you did. All right. Well, here's what I'm going to do. I'm going to go back and talk to my lawyer about it, and then I'll get back to you, because I would like for us to resolve this between us to save money in attorney's fees. And we like that. We really do.
Absolutely.
But don't sign anything before you talk to your lawyer.
We were talking, and I sort of strayed, I apologize, about talking with an attorney to educate yourself before you even get to a point where something's putting in writing.
Right.
Put in writing. Oh my God, I'm catching it from you.
Put in writing.
Yeah, but I'm the other point. The main point is, if you do put something into writing or receive something from the other side, absolutely do not just sign, because I can't tell you how many times people have buyer's remorse, or they don't realize the actual impact and effect terms will have on them because they missed something, they didn't put something in that should have been there, or they something was added that shouldn't be there. So have an attorney at the very least review it before you sign.
And don't be a penny wise and a pound foolish. It is worth paying the lawyer to review it. Hey, up next, we're going to continue to go over some of the most common mistakes we see clients make in divorces. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orsten. Todd and I are partners at the law firm of Merriweather & Tharp, and you're listening to Merriweather & Tharp Radio on the new Talk 106.7. If you want to learn more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we're getting into the common mistakes that we see people make in divorce cases. Not just people represented by lawyers, but people that try to handle the cases themselves. So we've gone through, 5 of them now.
So number 6, how about this? How about inaccurate information in a domestic relations financial affidavit?
Man, that is a hugely common mistake. And some people, they'll not take that seriously enough, and they won't focus and try to make sure all their numbers are accurate, or they'll give it to their lawyer at the very last minute because they need to file it with the court. And especially here in Georgia. Well, most states have a time requirement when you're supposed to file this before a hearing. And so people rush through it. They don't make it a priority. And then it gets filed and there's something wrong on it.
Yeah, because you have to understand that as a litigator, as a family lawyer, part of my job is to ensure that the other party's claims relating to their budget, meaning the information in we call it a DERFA, domestic relations financial affidavit, DERFA. So that the information in the DERFA is accurate. And part of my job is to explore why the information may or may not be as accurate as it should be. And if it's not accurate, then it calls into question, or at least it's my job to call into question, the credibility of that witness. Because if you are willing to put into a signed, document filed with the court and presented as evidence and it's a notarized document,
Mm-hmm.
if you're willing to put false information into that, what other false information are you going to give this court?
Right. That's the argument
That's
that
the
we
argument.
make. And even though it could be a simple mistake, now there are some judges that kind of blow off the domestic relations financial affidavit, but there's others that take it very, very seriously. They cite to it in their court order, their ruling, like, all right, I find this is what how we're going to divide things up on. I had a case once where, I mean, it's everything from income and expenses, but also assets, because I've seen someone listed on a financial affidavit $100,000 in jewelry. Well, when we went to have the itemization of the jewelry, we only were able to itemize $25,000. Now, my client also said that they had over $100,000 in jewelry, and that he had remembered buying all of it. That was their part of their retirement plan. I won't go into whether that was a good retirement plan, but that was they were, for whatever reason, that's what they were doing. Okay, so she was claiming, well, we only had $25,000. Well, I have a financial affidavit where she listed 100 and he listed 100.
Yeah.
So it looked very suspicious, like she had suddenly absconded with about $75,000 in jewelry.
And even because if we're talking about the actual, excuse me, damn, I'm getting choked up. The actual, tissue, do we have tissues? No, I don't need tissues out. Al's looking for tissues to get me. I promise I'm not going to cry. No, even if the court doesn't take that into account and basically, take the missing asset and assign, some value to a party, the impact on the credibility could be far more damaging. Mm-hmm. Because, in other words, let's say, there's $25,000 missing. Even if the court says, well, it's not there, I'm not doing anything about that.
Yeah.
But now the court doesn't believe you.
Yes.
That impact, that harm to your credibility in the eyes of the court can have a real impact and can influence the court's decision on a whole bunch of other issues.
And here's another thing. We're all about settlement. We're trying to avoid court if we can. But as lawyers, if we have an affidavit and we look at it and go, well, this is not accurate, I know that there are things that are not being disclosed here, we're now bound to go, okay, are they hiding things? This sounds like they're hiding things. Or when there's smoke, there's fire. And we have an ethical duty to explore that, or at least tell our client, hey, look, this doesn't look right. We can't explore it. Here's our avenues. We can do discovery and everything. So what happens is if you start the case off with a bad domestic relations financial affidavit, and then we're not talking about off by $5 or $10. We're talking about something significant. What it can cause the case to do is suddenly get more expensive, because the other side, and it could be driven by the client, not the lawyer, the other side suddenly says you're hiding money or you're not being honest about everything. So we need to do a lot of discovery.
And also, very quickly before we move on to the next one,
Mm-hmm.
Also, if you do one and you don't do a good job, then you do another one, and the numbers are different. If you don't think that the attorney is going to call into question the accuracy of your DERFAs,
Of both of them.
Because it's like, well, hold on one second. Here you said you have nothing, and here you said you have $100,000. Or here it was $50,000, and here it's nothing. Ma'am, 3 weeks between these two drafts, or sir, it's clearly one is very, very, very wrong.
Yeah.
Okay, so which is correct? Is it there's money or there's an asset or there's not? So you have to spend the time to make sure it's accurate. Okay, enough on that. Let's go to the next one, because I don't want to procrastinate.
Don't put it off. No, so procrastination, this is a little bit different than head in the sand, okay?
Yeah.
So you have people they don't have their head in their sand. They're very involved in the case, but they don't make their divorce a priority. And we actually had a whole show on how to make your divorce a priority. That, I think it was episode or show 53, if you wanted to go back and listen to it. But how to make your divorce a priority, you need to understand how to do that, because here's what happens. You have someone that is active in the case, or talking to the lawyer, talking about strategy, and the lawyer says, all right, here's what I need you to do. I need you to, let's say the issue is there's an assertion that the husband's an alcoholic and he's denying it. Okay, I need you to go and itemize. Let's say the client's like, I need to save money. Okay, great. Well, we'll let you itemize all the bank records and every time he made a trip to the liquor store and add it up for me. Great, I'll do it. I'll save money. A week goes by. I'm waiting on that, Excel spreadsheet. Have you been able to do it? Oh, no, I'm going to get to it next week. next week. We don't get it. Next thing you know, court is 2 days away and we still don't have the report because the person kept procrastinating. Don't put it off. If you have something high priority, and a lot of times, if there's kids involved, take advantage of the other parents seeing the children for you to do that work. The domestic relations financial affidavit is a great example. A lot of times we see inaccuracies because people procrastinated in doing it, and then they threw something together kind of sloppily. Mm-hmm. And then we as lawyers are obligated to take advantage of that for our clients. So
yeah, and let me say this. We have clients that will sometimes come to us at the end and they'll be like, why is this taking, why is it 8 months in, 9 months in, and we're not done yet? Mm-hmm. And we'll say, well, hold on 1 second. It took us 2.5 months to get some basic information. Then it took another 2 months to get responses to this discovery. And then it took another month or so to do X, Y, Z. And it's like the best way, if I could give any advice to anyone who has to go through this, it is, again, don't procrastinate. Be as active and involved in your case as you can be. Mm-hmm. Do things as quickly as you can, because then there is no excuse as to why you can't get to the table, start talking, negotiating, and try and get the matter resolved.
You remind me another reason why you don't procrastinate, because when you procrastinate, let's say somebody's asked for some discovery, or maybe it's financial information, and you wait to the very last minute to turn it over. Sometimes it can lead the other person to think that, oh, you don't want to disclose this. But if you get this discovery request and boom, within a week or two, you've turned over everything. Wow, that looks to the other side. They don't have anything to hide. They want to come to the table and negotiate something that's fair. And you increase your likelihood of, one, your case being less expensive, and two, you reaching an amicable resolution and through settlement rather than through trial. So,
all right, let's move on to, I'm going to sort of combine 8 and 9 together.
Okay.
This is the wild, wild west scenario. They don't shoot from the hip.
Yeah.
What does that mean?
So there's 2 areas that I think where it's important not to shoot from the hip. One is mediation, and 2 is court.
And what do you mean by, or what do we mean by shoot from the hip?
So shooting from the hip, it's actually a term that I think was there a movie called that? It was a lawyer movie. Or it was, anyways, I'm going to have to find that
I was speaking
now.
more, if we're going to get into movie trivia.
I'm going to have to go look that up, because there was a lawyer, and that was one of the discussions was he was shooting from the hip.
Right.
Meaning that rather than preparing, he was just walking in and winging it. He was just, boom, shooting, just firing off cross-examination questions without thinking about the merits of those questions. Like, am I actually leading the jury or the judge a certain way, or he's just rapid firing questions just to look good?
Yeah, and attorneys need to be quick on their feet.
Right.
So technically speaking, they need to be able to deal with any issues and shoot from the hip in dealing with those issues that may be those curveballs that come at you in the middle of a hearing or in the middle of a mediation. But that's not how you should be preparing for these things.
And so we're mainly talking about you as the client. If you're preparing for mediation, sometimes people think, well, mediation, it's really informal. What do I really need to prepare? Can't we just go and talk? And that's where a lot of people can get in trouble, enter agreements they shouldn't,
or not reach an agreement.
Not reach an agreement.
8 hours later, you're scratching your head wondering why things didn't get resolved. And people come to us and it's like, well, we already tried mediation, and we'll jump in, look at the file, and say, well, because you weren't prepared.
And up next, we're going to get into more of these. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orson. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. Here you will learn all about, today, the common mistakes that we see in divorce cases. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. All right, well, we got to go rapid fire.
Yeah, we were talking about not preparing for mediation, not preparing for court. So let's quickly go to number 10, which is failing to take an active role in your case. Okay.
Yeah, so I'm going to sort of tie that with those other two.
Absolutely.
Because what happens is people don't prepare for mediation, and so you need to take an active role. And if your lawyer's not, let's say mediation's been scheduled and your lawyer hasn't reached out to you to say, hey, let's have a pre-mediation meeting to make sure everything is we're on the same page with everything, what you want, make sure all the documents are together and everything. Take an active role and reach out to the lawyer to schedule a pre-mediation meeting. And then don't just do that. Show up with, so let's say you've got, 2 credit cards, 2 bank accounts, a retirement account, get all that stuff together. Get the most current statements. Come in to meet with a lawyer. Don't have the lawyer have to ask you for it. Bring in the most current financial statements that you have. Come to the table with here's what I'd like to see as far as parenting time, if there's kids involved.
Come in prepared.
Yeah,
generally speaking, come in prepared, because we could have a whole show on how to actively and properly prepare for meetings, and absolutely. But the bottom line is walk in prepared. There are too many people. Here are the extremes. The extremes are there are people who once they pay a retainer and hire an attorney, it's almost like they feel like, I'm done. I've done all that I need to do.
The lawyer's going to do everything.
Yeah, you do everything, and almost like a leave me alone kind of attitude.
Right.
And then there are people who want to, just micromanage. And that can interfere with the attorney-client relationship. And it also is something where you're never going to be happy because you're not trusting the attorney and the attorney's ability to come up with strategy and implement strategy. So you have to find a middle ground, but the middle ground absolutely should include active participation. Be proactive, don't procrastinate, and be a part of the team, because that's the way, when we're hired, the way that we like to think of it is it truly is a team. Yes, you're hiring us for our expertise, but we have to now work together to accomplish your goals.
Right. So when your lawyer says, I need you to come in to help prepare for court next week and talk about what your testimony is going to be, don't ignore it. Well, can't you just testify? Nope. You need to be take an active role in that preparation for that hearing. And here's another really important thing that I know we have a lot of things to get to, but I just think this is critical because we've seen these mistakes too. If your lawyer is not getting back to you, if you've taken an active role, and I'm not saying you're not micromanaging, I'm not saying you've called 5 times that day for the last 5 days. That's maybe a little bit too much. But I'm saying if you've called 3 times in a week and you haven't gotten a call back and there's a hearing around the corner, there may be a reason to be concerned. Because we've had cases where I've actually had 3 cases where the lawyer in the middle of the case was disbarred, which means they are not allowed to practice law, and they just kind of disappeared. And I actually had a call 2 weeks ago where the person wasn't getting called back, and I did some research. It found out the lawyer was in jail. He'd been arrested, and so he wasn't getting back to us. So you've got to take an active role. So in one case, the lawyer was getting notices of court, but he had disappeared and wasn't relaying them to the client. And so there was a hearing held without our client's notice. Thankfully, I got that one overturned because he had been disbarred. So the information should have gone directly to the client. Anyways, when you take an active role, that also means you're holding your lawyer accountable.
Right.
So that's what I wanted to make sure we threw that in there.
All right, next one.
All right. Firing off emails or texts when you're angry or tired.
Yeah, we've spent significant time on that in previous shows, but just to repeat, we are all to some degree driven by emotion, right? We are emotional animals. I'm not trying to play the therapist here, but it's true.
It's true.
All right, and so I am just as guilty as everyone else when somebody upsets me or angers me, that I want to sit down at my computer and just start typing, tap, tap, tap. And I'm like, oh, when you get this. But we train everyone at the firm, and we train ourselves to, once we are done tap, tap, tapping, walk away.
Yeah.
Take a deep breath. Don't put an address into the send portion of the email.
Or the to portion of the email.
So that you don't accidentally send it before you have
Don't type it if you're on a phone.
Yeah.
Don't type it as a text message.
Yeah.
Type it in the notes section. Most phones have a note section. Type out your email or text message you want to send, but probably shouldn't.
Because words can hurt you.
Yes.
Okay, they don't hurt you physically, but as we have
hurt you in
said,
court.
as we have said time and time again, sort of like the Miranda warnings, anything you say can and will be used against you in a court of law. So if you say something ugly and angry and insulting, be prepared for that to get thrown back in your face at some point at the appropriate time in front of a court. So be careful what you do and what you say.
Yeah, and so avoid it when you're tired, because sometimes you say things, you don't use a filter because you're tired, and when you're angry, definitely don't do it.
And if you have the ability, we in our firm have a second eye policy.
Yeah.
We want people to review those types of communications to make sure that, hey, I may be too invested here and too, emotional on this issue.
Yeah, sometimes you can have your lawyer look at some of them. And we even had Diane Dirks on the show who, she's got a class where she goes through and says, and looks at your text messages and your emails to help you write better messages to the other spouse or ex-spouse.
Okay. All right. So next one, calling your lawyer so many times that you use up all your money on phone calls and they have to withdraw. Okay.
And we've had to do that. I hate to do it, but we've had situations where the client would call or would call so many times during the day that it would just chew up the retainer, and then they ran out of money and we had to withdraw. So we get paid by the hour. So, and we have a whole show. We had a whole show actually a while ago. We need to do another one on how to effectively communicate with your lawyer. So
I once had a client very quickly. I had a client who left and was with another attorney and complained about the billing and was very upset. And I looked at the billing and there were just hours of phone calls, hours of email, hours of even in-office meetings. And she came in and started to act the same way. And I had to stop and say, all right, hold on one second. I know you weren't happy about the billing over there, but you need to start, and I didn't say it this way, but it was like, you need to look in a mirror. You need to understand that your behavior is resulting in some of these costs. You need to understand how to effectively and efficiently communicate with your attorney, because if you do that, you're going to cut your bill by, 25%, 50%, 75%.
And you'd rather have your lawyer prepare your settlement paperwork, prepare you for mediation, rather than being on the phone all the time. Not that we don't want to talk to people. We just want to be efficient with the time we spend on your file.
Yeah, and instead of sending, 50 emails with one question in each email that requires a response to each email, send one email with 50 topics or 50 questions. Then the attorney can say, oh, okay, well, that's organized. Let me go through. Answer. Here's one email response. And what took, 20 minutes to respond to all those things, what didn't happen is instead of it being, 50 minutes or 2 hours responding to 50 different things, it only took 20 minutes.
All right. So the last one, I wish we had more time for it, but lying. That might be one of the worst mistakes that you can make in a divorce. Absolutely. Is just flat out lying during the course of the case. That will get you in so much hot water. I have seen judges get so angry from the bench because someone lied to them, perjured themselves on the stand. There are some situations where you can be arrested for that, for perjury, but there are definitely situations where we have seen, to the benefit of our client, when we caught the other side on a lie in cross-examination, where they got hammered at the end. My client got, 80% of the marital estate when normally it should have been maybe 50 or 60%, but because the other side lied, boy, there was a $200,000 swing in what what recovery was for my client.
Yeah, there's, as I said before, I know we're almost out of time. It's all about credibility. And if you lie and get caught in that lie, and first of all, an attorney shouldn't be letting you lie, but if you get caught in a lie, it could be the smallest little white lie. It could damage your credibility, which can then impact what the court does in terms of a final order on all the issues.
Yeah. Well, hey, thanks everyone for listening. That about wraps up this show. If you know what, if you're getting a lot out of the show, we would love it if you could review our show. There's you can check us out at mtlawoffice.com/review it. That will give you instructions on how to review the show. You can also watch the show at youtube.com/Atlanta Divorce Lawyer. Thanks again for listening.
This audio program does not establish an attorney-client relationship with Meriwether and Tharp.